Welcome, everyone. It's great to see so many people here. This is a very, very important subject. Like anything else, modern communications and data storage technology has benefits and risks for lawyers, and for lawyers, I would say, to even a greater extent than non-lawyers, citizens. This is really a big civil liberties issue. We have a government that's basically spying on us every day in ways that George Orwell never, would even have imagined. But what can we? We put on programs all the time, and you're basically talking to each other. How do we go beyond doing that? What do you think there's an effective path?
Yeah. I think first of all that regulators are going to, even if Congress doesn't move, regulators are going to increasingly tighten the screws and require and expect more action by professions in order to protect the data they hold. The FTC, for the first time, has actually fined the victim of a breach for not having these common sense measures in place as a hotel chain, and I expect the bars to similarly implement and enforce their ethics rules in increasingly strong ways, and we're already seeing that in some Texas decision and others. And so, I expect the bar's enforcement capabilities to be more focused and learn more of the tech. But then, I think the bar itself should put some funding and some standards together towards creating, open source software that's secure and trustworthy, and that is affordable to solo practitioners. Making sure this software is available, is vetted, is discounted perhaps, and then training individuals to use that software, I think, on an ongoing basis, is a real role that the bar can play.
Everybody here tonight can walk away and do all these things. You can go get Thunderbird with Enigmail and do encrypted email. You can get Box Cryptor for an individual and encrypt everything on your drive. Lots of the cloud providers have encrypted data there. You can do all these things without a lot of expense and a lot of effort. If you're getting into e-discovery, I showed you an e-discovery tool that didn't cost $500,000. And we're going to, in future versions of this series, we'll introduce you to more relatively inexpensive technologies. Up to everybody here to sort of catch fire. That attorney that got sued, we were talking about earlier, I bet that individual is probably looking into the ways to get an encrypted email if their practice doesn't go under after that case gets out there. So you don't have to get stung like that individual. You shouldn't have to get stung. You should be. That's why you're here, I guess. Everybody here, we're not selling anything that you guys don't know. That's the reason you're here. Ethics in technology is a natural marriage. Going forward, all the more so.
And I do also want to touch on the civil liberties issue. So I think this is also the greatest civil liberties question of our age. And constitutional communications, the implication is that our current systems of communications are not constitutional. If you look at the way the government has been treating them, we don't have basic constitutional protections, whether it's First, Fourth, or Sixth Amendment, within the current framework, and we need to incorporate those. The judges as a whole have been dodging the issue and allowing the government national security exceptions for things that clearly don't involve national security. And so we don't have good judicial opinions, but the bar can play a key role in ensuring that attorneys are able to, at the very least, protect our clients and protect our profession, given this, and also advocate for constitutional protections that apply to society as a whole. But a very easy way to start that process is what Peter's been saying, which is that you create an actual requirement that then the bar can help support basic technology encryption that already exists, that then can be free and open source for all attorneys to use, so you don't have large firms competing with proprietary solutions where you're never going to get everyone to adopt anything. You just have an open source solution that everyone can use, and all attorneys, it has been vetted by technologists, and we don't need to have it be sold at all. It's a public service that's offered by the bar to attorneys that can ensure that we can maintain a profession that has security regardless of whether or not the government is actually taking constitutional action or not. The thing that's kind of mind-boggling about this conversation is that folks at this point now, because of WhatsApp using end-to-end open source encryption for their products, there's about 1 billion users of WhatsApp. Most of them are in the third world. So when I WhatsApp with, I have friends that are peasants in Brazil, my communications are actually way more secure than when I talk to an attorney here in the US. And that is a mind-boggling thing, but that's the reality, and that's why we need to change these standards, because of the fact that currently the technical solutions exist, but attorneys are not being included in them, and it's undermining the public's confidence in our profession. And yet you have 1 billion people who are using mobile devices from, farm fields who have a much higher level of information security than the average attorneys in this room. So that's, or most attorneys that don't use encryption regularly.